Thank you for joining us as we resume our Thursday deep dive webinars where we focus on a specific topic. My name is Anna Hall and I'm the CEO of the Northeast Charter Schools Network. Today we are thrilled and I am personally so gratified to be joined by Amy Bess, Chair of Vedder Price's Global Labor and Employment Practice Group and a member of the firm's board of directors. Amy has practiced in the area of labor and employment counseling and litigation for more than 30 years, representing employers of all sizes in a variety of industries, including education, professional services, nonprofits, government contractors, and retailers. I am personally very gratified to have Amy's counsel on these complicated topics, as she has consistently provided some of the most helpful, experienced HR advice that I have received over the years that I have been working in the charter sector. Before we dive into a conversation with Amy featuring many of the personnel-related questions we've heard that you have, let me briefly remind you that we will be hosting our weekly Tuesday webinar with the state's authorizers next week and for the foreseeable future. If you have any questions or content that you would like to see covered, please let us know. We're also looking forward to next Thursday's rescheduled Race, Justice, and Equity conversation with charter educators on Thursday, August 6th at 4 p.m. We're also excited to announce a partnership with Google Classroom, where we will be offering a workshop with their exclusive content, and be on the lookout for more details about that coming date. As always, if there are other topics or content you'd like to see covered, please let us know. With that out of the way, Amy, thank you so much for joining us. As I'm sure you're aware, charter schools in New York recently received a lot of guidance about returning to school from a student and facility perspective, which raised a lot of questions about staff and liability. We have some questions prepared in advance that would love to get your thoughts on, and then if there's time, we'll take some questions from the Q&A. A lot of the questions we've heard center on at-risk staff, both how they're identified as well as accommodated. So to start off, what should a school do if they request that some or all staff return to their building and have some that refuse to return for various reasons, including underlying health conditions, staff who has to travel to work on public transportation, who's worried about contracting COVID while commuting, staff who lives with family members who have underlying conditions and are at risk, particularly vulnerable to COVID, staff who have childcare obligations because their own child's school is closed due to COVID or has an incompatible remote hybrid schedule for their child's school, or even just staff who are particularly concerned and expressing fear about coming into the building and resuming their duties due to COVID. Any thoughts on all of that?
I have a lot of thoughts, Anna, as I'm sure you are not surprised to hear. But first of all, thank you for inviting me today, and it's great to see you again. And it's an honor to be here. So thanks again for inviting me. This is an issue that is probably the single biggest issue we have heard from our employer clients at my firm and in my practice group, because each of these situations is very, very fact specific. And, we also are looking at these issues sort of through the prism of having just been, most of us, in a very remote work setting. So we've just come off of, or possibly are about to come out of, a situation where most, or if not all, of our staff have been working remotely. And some have been doing it relatively successfully and some not so successfully, but we didn't really have a choice. And so we were sort of thrust into that situation because facilities and businesses and schools were closed. So we really had to make do. That doesn't necessarily mean that every single person out there can really perform the essential functions of their job while working remotely. And so some of the threshold issues that I think you have to look at here before you get into the very specific situation of why the person is unable to come to the facility or is afraid to come to the facility or feels at risk of coming to the facility. Some of the underlying issues really are if the school is reopened, while you might have been teaching remotely when you were doing distance learning, and so all of the teachers were struggling to teach remotely, all of your students were remote, even your staff was remote. You might have had an office manager who was, trying to do their job remotely, a dean of students who was doing their job remotely. You didn't really have a choice. That was what everyone was doing. But now assuming the buildings will be reopening, and if students are back in the buildings, it's not the same situation where you have one teacher trying to teach a class from their home when the class is physically in the school. So it's a very, very different situation. And I would argue that teacher cannot perform the essential functions of their job while working remotely when their class is in the building, is back in school, and all the other teachers are back in school. So with that kind of as a threshold issue, you have to look at the individual circumstances. So if somebody has an underlying condition that would potentially rise to the level of a disability under the Americans with Disabilities Act, remote working could be considered a reasonable accommodation. So in a normal circumstance, in an office setting, for instance, if somebody could perform their duties from home, and they cannot come into the workplace for various reasons because of their underlying condition, allowing that person to do their job from home could be a reasonable accommodation. That assumes, though, that they can perform the essential functions of their job from home. I would argue that in this particular situation, even if the employee, the teacher, or a staff member, if they have an underlying condition that is a disability, and they are, and all of the rest of the school is back in the building, it's going to be very difficult to argue that person can perform those essential functions successfully from home. So, so remote work and I would say likely will not be a reasonable accommodation in that particular situation. And that's even if somebody has an underlying condition that rises to the level of a disability. Now, if the other issue, another situation that you identified would be someone else in their household or a family member or partner has a condition that makes them vulnerable, and the teacher or the staff member is afraid to come to work because they don't want to contract something and then bring it back into their household and potentially infect a family member. That is not a situation that's covered by the Americans with Disabilities Act, because it's not a disability that individual has. So that's an even further removed situation from what we were just talking about. That is not something that you have to accommodate under the ADA. It's depending upon the employer, they may want to give that employee some time off, perhaps under a leave of absence policy. But at the end of the day, you have to ask yourself, how long is this situation going to last? And will that person, when will that person be comfortable coming back into the workplace? When there's a vaccine? Well, that may not be any time in the near future, unfortunately. When the pandemic goes away, that also may not be any time in the near future. So you're looking at a situation where you're trying to work, generously and compassionately with your employee, given their fear situation, but there may not be an end in sight and their leave will long run out, and the situation may not have improved. So the fear, which would I think would cover a situation where the person has a family member that they're afraid is going to contract something that they would bring home. They themselves are worried about contracting COVID. They're afraid to travel on public transportation for fear of contracting COVID. All of those situations, those are not disability-related situations that must be accommodated, or at least you would have to engage in an effort to try to accommodate. And those are situations where you just have to have probably a very tough conversation with the employee. And, unfortunately, we've had to advise some employers where the employee just simply will not come back to the office, even though the job is, requires that they be there. And there's not an end in sight that they may have to part ways. So those are very tough conversations to have.
And as a follow-up, one of the questions that New York City schools in particular have asked a lot is that the DOE actually created a portal and a platform for DOE staff members to essentially register and request a desire to work from home. And it's not entirely transparent to charter schools what is included in that platform and how those determinations are being made. What I think I'm hearing from you is that the overriding principle of law here remains ADA reasonable accommodations, as opposed to any of these other outside precedents or sort of individual circumstances that are being developed, even if they are by organizations as large as the DOE. Is that accurate?
Yeah, there is. And I mean, unless there is a legal mandate that requires that you allow your employees to work remotely, and that was the case when employers were, their facilities were shut down and you didn't have a choice. You really have to look at the situation kind of on a case by case basis. And if there is not a duty to reasonably accommodate somebody under the ADA with remote work, and again, that situation is qualified by whether or not they can perform the essential functions of their job. The reasonable accommodation is only an accommodation if it will enable the person to perform the essential functions of the job. And if the job cannot be done remotely, then working remotely is not a reasonable accommodation. So yeah, you're right, Anna. You have to look at it through the lens of, do you legally have to do this, or is this something that you're trying to put in place practices and policies that are designed to help your workplace, thrive and survive and function. Mm-hmm. And, some employers, to be sure, have in fact put in place very liberal remote work policies that are far beyond what they would legally have to do. But they're doing those because they have such a vast number of employees who are afraid to come back to work, that if they don't, they're worried that if they don't put in place liberal remote work policies and procedures, they might not have, a workforce to do it. Mm-hmm. So it's a challenging situation, and I think a lot of employers are doing different things, but I think in the school setting, you really have to look at, if school is back in session and your students are in the building, then it would seem appropriate and necessary to have your teachers back in the building too. That seems like a basic premise.
So two sort of wrinkles on that came through the Q&A, which I think are good questions. One is about staff PD. So as I know from years of working with charter schools, many schools put a huge priority on staff PD before the first day of school. That's a return for students. So I think first question is, can a school define staff PD as an essential work function which could not be accommodated remotely, as you're talking about under ADA? And then I think the second wrinkle is, in an environment where some staff and students are back and some are not, if the school has made a determination that, I'm pulling this out of thin air, all kindergartners are going to be in person, and there is a kindergarten teacher who does not want to return in person, how does that impact this at all, where it's not a total, we're all in or we're all out? There are some people who are in and there are some people who are out. Does that change the nature of what could be considered a reasonable accommodation?
Mm-hmm. Those are really good questions, and not easy questions, to be honest. With regard to the professional development, to be honest with you, it totally depends on the nature of the professional development program, and whether or not that needs to be in person. You have to kind of look at how you would deliver that remotely. As I understand most PD programs, there is a lot of interaction. There's a lot of, face-to-face dialogue. There's a lot of, role playing and things like that. If you could accommodate, if you could manage to do that successfully remotely, there may be a legal argument that you would have to accommodate somebody who cannot be there physically in person because they have an underlying condition, and that if they were in person would potentially make them more vulnerable to COVID. So it's hard to give an absolute black and white yes or no answer on that one. I would say that it depends on how the PD is delivered. If someone could make an argument that, most of this is PowerPoints anyways, kind of thing, right, that's different than if, yeah. And if your PD is really just all of your staff would be sitting in a room watching a PowerPoint or listening to a speaker deliver a training in the front of the room, then I think there would be a very strong argument that that could be done remotely. People could log in to a Zoom call, and those speakers could just be like you and I are right now, you know. So the question is being there in person essential to receiving that training, or could they receive that training, you know, as successfully, or with some modifications, some minor modifications remotely. So it's hard to say that all PDs absolutely would have to be delivered in person, and that would be deemed an essential function of the job. With regard to the second issue, and I forgot what I've forgotten what your second question was.
If there's some staff and students are present and
Right,
some are not,
right.
and a staff member who doesn't fall into the, you know, perfect design, like they would normally be expected to be present, but some of their peers are not and are working remotely, you know, do they have a persuasive argument to say, like, you know, I'm a third grade teacher, but I know that fifth grade teacher isn't here.
Mm-hmm.
And so talk to me about why my specific role means that I don't have that flexibility.
Yeah, well, you know, again, there's sort of gray areas, and there's arguments to be made. Most of these situations that we're talking about right now have not managed to make their way into litigation yet, and there's not case law decisions that will guide us and sort of give us kind of concrete answers, yes or no. But the way I would look at those situations, I think that if you're talking about within a grade, so if you have some kindergarten teachers who are working remotely, I know this wasn't exactly your example, but if you have some kindergarten teachers who are working remotely and some kindergarten teachers who are in the building, and you have, say, a kindergarten teacher who is expected to be in the building who has an underlying condition or is fearful or whatever, I think it would be a very hard argument to say that person couldn't work remotely, because there are kindergarten teachers who you have chosen to have work remotely, and clearly that you've made that decision that can be an effective way to deliver at kindergarten training or kindergarten education. I think it's a different argument perhaps if you have all of your kindergarten teachers in the building, and maybe all your fifth grade teachers working remotely, and you have a kindergarten teacher who says, well, the fifth grade teachers can work remotely, why can't I? You then would have to look at it from the perspective of, well, what is the curriculum that we're delivering in the kindergarten classes that we feel is essential that the students be getting face-to-face and hands-on and in the classroom and that kind of thing. I also think that there's if all the fifth grade teachers are working remotely, my guess is the students are remote too. That's a totally different situation. I can't honestly imagine exactly how you do this effective teaching where the teacher is on Zoom and the kids are physically in the building. I mean, there's just a disconnect there that I don't think really works. So I think it's a little, it's a nuance. Your sort of example makes it a little bit more nuanced than if you had everyone remote, students and teachers, or everyone back in the building, all students and teachers. Clearly, if you've got some teachers remote and some teachers in the building, some students and some, in the building and some not, it makes a little harder argument to say that teachers can't work remotely, because obviously you have some teachers that can. I still would argue that it's you make the argument based on the grade and the specific requirements of that curriculum and what those teachers need to be delivering. So I think there's still an argument that could be made that the teachers in that kindergarten example, need to be.
And so just to take this back to the 50,000 foot level again, the controlling legal premise here is ADA, which defines certain categories of disability, which creates an expectation that teachers or that staff. I'll be right there. I promised we would make brownies today. We will make brownies after this webinar. So ADA is the legal precedent which establishes categories of disability. So it's not like, everything under the sun. establishes the expectation that a staff would have medical documentation associated with their disability, that they would have to disclose the disability. So I'm raising this in part to answer some of the additional sort of wrinkles of these questions that are coming through in the Q&A, and that, so something like anxiety would have to have been medically diagnosed, disclosed to the school. And so maybe could you, so if I'm getting all of that right, could you also maybe say a little bit about if a school leader feels like they're starting to go down this road with a staff member, right? They're starting to either hear explicitly about concerns or things like that. What should they do? How should they respond? What can they ask for? What should they be saying back?
So your questions are excellent, and those are all very, very important considerations. One thing I didn't mention before, and I should have, is that the underlying condition that might rise to the level of an ADA disability could be a physical disability, like it could be diabetes or asthma, some of the conditions that we've heard of that make a person more particularly vulnerable to COVID. It also could be a psychiatric or a mental disability, mental health disability, like a diagnosed case of anxiety or PTSD or depression, which could rise to the level of an ADA disability. It can't just be sort of a generalized fear that has never been diagnosed, but people just, we're all afraid of COVID, we're afraid of getting COVID, and that's a legitimate concern, but it's not a disability under the ADA that you're afraid of getting COVID. So yes, it would need to be a diagnosed disability for which the employee can obtain medical certification. And so what you're talking about when a school leader is starting to go down this path and a staff member brings to their attention that they have this condition that's going to really impact their ability to come back, that dialogue is called an interactive process. It's a term of art that's used in the ADA kind of setting, and it's required. The employer must engage in the interactive process with the employee to explore reasonable accommodations. Because the idea behind this dialogue, this interactive process, is that the employer is not an expert at what this employee might need. They don't know anything about their condition. They don't know anything about the unique abilities or inabilities or limitations that this disability might pose to this employee. And so the whole idea around this dialogue is to really explore. And in the ADA context, an employer actually has the ability to ask some questions about the condition and what the employee's limitations are. They should focus that dialogue and those questions only on the requirements of the job. So they can't just use this opportunity to poke around and pry into this employee's health history just out of curiosity. That's not the point of this. The point is,
I heard you got together with so-and-so yesterday. It didn't sound like you were afraid then.
Yes, yeah, that would not be a good question probably to start that dialogue anyway. But you start by talking about what this employee's limitations are, and specifically how they limit the person's ability to do the job. Here you're probably going to be focused mostly on their ability to get into the building and to come in physically into the building. And so it's probably going to be a much more focused conversation. You are, as an employer, entitled to have medical documentation to establish the employee's condition and how it limits them. There are some very strict limitations and guidelines around what you can ask the doctor to certify. We've used what we call a reasonable accommodation questionnaire, and it's very, very much tied to the job description. And we attach the job description. We ask the employee to take this questionnaire to their doctor, and the questionnaire asks very specific questions about the condition, how it limits their ability to perform the essential functions of the job. It asks the doctor to examine the job description and then to provide any suggestions around reasonable accommodations that might be available that would enable this employee to perform the essential functions of the job. Because again, the whole key here is the disability has to limit the person, but an accommodation has to be able to bridge that gap. The accommodation has to enable that person to perform the essential functions. So if the accommodation doesn't do the job and they still can't meet their job requirements or the essential functions, then it's not a reasonable accommodation and it does not need to be provided. So for that reason, if the issue is that the employee is sick and needs to be home, that's one thing. But the leave of absence, for instance, could be a reasonable accommodation. That leave of absence has to essentially enable the person to get back to being able to perform their job. So an open-ended leave of absence that may last for some indefinite period would not be a reasonable accommodation.
So I know we could probably spend the whole rest of the time just on this piece, but there are a whole host of other related issues that I know people are curious to hear answers to. So can schools require that all staff, students have to present proof of a negative COVID test in order to return to work and to school?
It's a really good question. I don't think there's a legal reason why they could not require that. However, I think it's a really bad idea, and I just don't think it's practical. I mean, we have even gone to the point of saying to employers that forcing an employee to provide a negative COVID test after they have taken a leave of absence because they have been ill with COVID, and requiring them to present a negative COVID test to come back to work is not necessarily even a reasonable expectation. Because first of all, negative COVID tests, there are a number of COVID tests out there where employees or where patients get false negatives. So even under the CDC guidelines, if you're going to use a negative COVID test as your indicator that someone is safe to come back to work after they've been tested positive or had exposure, they need to have 2 negative COVID tests within 24 hours, with a 24-hour gap in between. So, which is
hard to just accomplish
right,
at scale.
Right.
Yeah.
So, and then on top of that, you have the additional problem that you're seeing everywhere, that COVID test takes, anywhere between 7 days and 10 days to get back. So anything can happen in that 7-day window. So if you have a COVID test on a Monday and you don't receive your negative test results back until the following Monday or Tuesday, you could have gotten re-exposed in that interim. And so it's really not a very realistic. First of all, it's not a practical and realistic expectation. And secondly, it's really giving you a false expectation of security that may or may not be, legitimate and reliable. So I would say it's a good idea perhaps, but it's really not a very effective idea, unfortunately.
That's helpful. So then many folks, and we've seen some questions in the Q&A about this, are aware that there have been changes to leave policies and law regulating leave policies. So can you outline what those are and how long that they last?
So the Families First Coronavirus Response Act, which was a legislation that was passed, I think in March, put in place 2 different types of additional leave that were available for employers that were under 500 employees. And so if you employ under 500 employees, you are obligated to provide 2 types of leave that are available between the date of the enactment and December 31st of this year. One is an expanded paid sick or emergency paid sick leave, which is up to 10 days of paid sick leave that I think is capped at, I believe the cap is $200 a day, and that is provided for an employee who is suffering from their own illness related to COVID. Either they've been tested positive for COVID or they're suffering from COVID symptoms. It's also available if someone is caring for someone who has tested positive for COVID or is experiencing COVID symptoms or has been required to quarantine. And it also is available for someone who needs to provide care for their children because their child care, their school, or their daycare center have been closed or canceled because of, and that could even include summer camps, have been canceled again due to COVID. And so that's one type of the leave. There's a ton of regulations. There's a lot of nuance around that, but that's essentially the basic requirement of the emergency paid sick leave. And then there's an additional provision under the Families First Coronavirus Response Act, and that is for what has been called expanded FMLA leave. And FMLA normally, the Family and Medical Leave Act, is normally only available to employers who employ 50 or more employees in a 75-mile radius, and then the employee themselves has to have worked for the employer for a year and 1,250 hours in the past 12 months. So it doesn't apply to everybody. This expanded FMLA applies to anyone who has been with their employer for, assuming the employer is under 500, anyone who's been with their employer for only 30 days. So even if you were not previously covered by FMLA, this expanded FMLA leave could be an option. Now that one is limited to situations where the employee needs to take leave to care for a child for the same reasons that I just described. Childcare is closed, school is closed, or daycare provider is unavailable, again, all due to COVID. And that is, that provides the first 2 weeks are unpaid, although the person can use their emergency paid sick leave for that first 2 weeks if it's available. And then the total amount of leave under that expanded provision is 12 weeks. So it's a long stretch. And that is paid at 2/3. After the first 2 weeks of unpaid, it's paid at 2/3. Again, there's a cap. There's a bunch of regulations and nuances around that as well. There are, the DOL has put out, the Department of Labor has put out a long list of questions and answers that are available online. There's, I think, 56 or so questions and answers that provides a lot of good information. There's a set of regulations that have been enacted. So there's a lot of good information out there. There is a posting that's required to be, the DOL has put up a posting that needs to be posted in the workplace that kind of lays out the basics. And we've put together some forms that I think are really helpful for requesting that kind of leave and then designating that leave, et cetera. So, and I'm happy to anybody who wants to reach out after today and request it, I'm happy to share some of those forms that we put together, just some templates that at least could serve as a starting point for some folks that might want to put something like that in place.
That'd be fantastic. And if I could impose on you further, there were some questions in the chat when you were mentioning the medical questionnaire. If you had even an example of that and were willing to share it, I think
absolutely happy to do that.
That'd be super helpful.
Mm-hmm.
So a follow-up question in terms of leave. So if an employee is already allowed to work from home, so maybe that's because they've been given an accommodation, or maybe it's because everyone's remote or under the hybrid model of their school, their role is specifically remote, but because of some of those childcare obligations that you were just describing that entitle them to leave, can they be required to take a leave of absence? Could they be eligible for some of this paid leave if they, technically are already working from home, but they either by their own description or by the school's assessment are not able to meet their job responsibilities?
Yeah, it depends. It's going to depend a lot on the particular circumstances, but I would say generally the answer is yes. That if the person is already working remote, but they have these additional childcare obligations, or they need to homeschool their children and focus on the distance learning, then they could definitely.
Or make brownies, apparently.
Yeah, exactly.
It'll be done outside of working hours, friends. Not to worry.
Yeah, and that's a tough one because, you know, sometimes, and we saw this a lot, and I'm sure a lot of the folks on the call today did as well, where when you were all working remotely, you didn't necessarily know, and schools were closed, and so a lot of your employees they were juggling lots and lots of balls in the air, and you didn't necessarily know if they were actually able to work, you know, a full day or not, because they were dealing with childcare, they were dealing with homeschooling. So sometimes it's hard to figure out if your employee is actually able to meet their job requirements, or if they are spending more time during the day really taking care of kids. And so you have to, sometimes you have to have some really tough conversations. But it's, you know, it's a performance-based issue. And once that comes to a head and you have that conversation, you may learn that the employee really is only able to work about a part-time schedule, and the other half of their time they really need to, you know, spend on taking care of their kids. So so that may sort of necessitate that conversation around, do they really need to maybe take a leave of absence, and these are some options that might be available to them that they weren't even aware of.
So transitioning a little bit to the potential for the sort of physical component of staff and students returning, whether it's all or just some. Should schools be are schools required to provide staff with PPE, or is it better that they require that they provide their own? And should schools be creating any policies or guidance about PPE? So for example, wearing masks, handling masks, hand washing, things like that.
Yeah, so I'll take it in reverse order. Definitely, schools should have guidelines around those sorts of issues. You know, what is expected of employees in their workplace at all times, and it should be very granular. You know, so it should talk about social distancing. You talk about congregating in places where, you know, where you cannot maintain social distance. It should talk about mask wearing. I do not think that it's the best idea, frankly, for employers to try to start providing PPE to employees, because once they do that, then they have a lot of obligations with regard to maintaining it, cleaning it, and all that kind of thing. I think the better option is for employees to wear their own masks in the workplace. But the guidelines that you've established should definitely set forth exactly what your expectations are and your requirements are, and they should be consistent with what the local Department of Health requirements necessitate. I do think, and I think it's a best practice to have extra masks and extra, especially if you're requiring, you know, students to wear masks. They're not always going to bring their masks. They're not always going to remember how, you know, to bring it from home. And you just have to have things, you just have to have extras on hand, both for staff, frankly, and for students. We have created another document we've created that I think that I'm happy to share is just a one-page guideline on how to take care of masks, which I know sounds kind of like a no-brainer, but it's, you know, it just talks in kind of detail around how to remove a mask safely, how to put a mask on safely. I think that those sorts of documents should be shared. If you have like a portal of some sort for staff that they can log into and see all those documents and have them online, that would be ideal. You can post them. I would do as much, I would repeat it as often as you can. So post it, put it online, have it in hard copy. Those are the kinds of documents that are really, really important to have in place. So I'm happy to share that when I give you some of the other materials, Anna, for you to share. It's just a one-pager. It talks about how to take a mask off successfully, how to wash a mask, how to put it on.
That'd be great.
Those are important things to have.
I think folks would appreciate that. So follow up to that, what recourse is available to schools if they've done all of that? They have your amazing one-pager, they've, you know, mailed it, emailed it, posted it, everything they can possibly do, all of the best training and guidance, and the staff member is not complying.
It's a disciplinary issue as far as I'm concerned. You know, just like any other policy or procedure, the difference here is that you're trying to keep your entire workplace and all of your students safe. And I mean, that's that's different in terms of its sort of heightened sense of importance than, frankly, whether a staff member has complied with your dress code or, has called out in, that they're going to be absent and, made the call by email versus by phone or text message or whatever your policy is with regard to call outs. This is a really, really important issue. You are, and frankly, all of the, the federal, state, and local governments, the CDC, the EEOC, all of them are on your side on this. So when you have the risk of a direct threat in your workplace of someone coming in without proper protective gear or without a mask on and potentially contaminating or infecting their coworkers or their students, it's a huge, huge issue. And you have every right as an employer to require that they follow the rules. And so, it's a disciplinary issue, and I would treat it aggressively.
That's great. I absolutely agree, but I think it's, it's going to be difficult. And so it's great for schools to hear that. Mm-hmm. So moving on to a couple of liability questions that we've received, and I think there are a couple similar ones that have come up in the Q&A. So can or should schools have families or staff sign some sort of agreement or a waiver or a disclaimer that absolves the school of any potential liability?
I think I think there is room for families to sign on to something, but it's not technically a waiver. I think it should be an acknowledgement, a certification perhaps, that they understand what the policies and procedures are around maintaining a safe and healthy school environment, and so they are agreeing that they will abide by those, and that their student will come to school with a mask, that they will exercise appropriate hand hygiene, that they will maintain social distance, that they will follow all the rules. And those rules should be set forth in that document, and then a parent should sign. And I think that's a great idea. But the idea that you could somehow require parents to waive any future unknown liability around the possibility that their student might contract COVID at school, I'm not certain that would even be enforceable. And then you also run the risk that you're not even going to get half compliance. You're going to get families who would absolutely refuse to sign that. So then what do you do? And then there's just the optics of that. I think the optics of that are very sketchy. So I would not suggest that having them sign a waiver is a good idea. I do think, though, that there is a lot of, just like you would ask your families to sign off on, say, a student family handbook or something like that, it is very important for them to understand in black and white what the rules are, and to agree that they will cooperate and partner with you in ensuring that their students are complying with those rules. So that to me is the biggest the biggest key here, is that that the rules are in place, the guidelines make sense, they're well communicated, and then everyone signs on to agreeing to abide by those.
That's great. And so then if a student or a staff does contract COVID, and they believe that it was contracted in the school setting, is the school liable? Can they be sued? And would it matter if they had not been following the guidelines, or if there was some belief that maybe it was not actually contracted at school? What is the sort of liability context right now for schools and COVID in general?
Yeah. So this is a topic that has been up for a lot of debate, and there's legislation that has been talked about in Congress about limiting exposure to liability for COVID-related illness and liability for businesses. I'm not sure exactly where that's going to go. That's being hotly debated right now. One thing that is very clear right now is that, and this has just been the case for a very, very long time, is that when you're talking about liability to an employee in the workplace for their having been injured or contracting some sort of an illness, those those situations are going to be governed by workers' compensation. And so workers' compensation, for which employers pay insurance premiums, there's a preemption, which means that really any injury or illness that happens in the workplace is going to be subjected to the workers' compensation kind of framework, kind of rubric. So employers are protected by the fact that they carry workers' compensation insurance for any claims that relate to an injury or an illness that was contracted in the workplace. Now, with regard to COVID, that's probably not even going to be covered by workers' compensation. So it's not even likely that an employee will be able to file a workers' compensation claim arguing that they contracted COVID in the workplace, because there's this concept under workers' compensation where if it's an illness, which is often very, very difficult to establish was contracted in a workplace, the illness has to be one of those that is peculiar to the workplace in question. So, there's all those situations years ago around contracting, like coal miners who contracted asbestosis, and was that covered or not covered by workers' compensation? In the COVID environment, if you're a healthcare worker and you're exposed to COVID because you're caring for patients with COVID, then that would be a situation where, being exposed to COVID is peculiar to your duties and responsibilities as an employee. But COVID in a school, or COVID in an office, or COVID in a typical business, it's just not peculiar to your responsibilities. So it's probably not going to be covered. But that doesn't mean that then the employee gets to come back and sue the employer for that. Workers' compensation still provides sort of the exclusive remedy. So that's the employee situation. In terms of a student contracting COVID, and then suing the family, suing the school, it's a really hard. I don't know, frankly, the answer to that question, whether that case would even be able to be brought. The only way that it would even remotely make any sense at all is if the school or the facility had completely shirked any and all responsibilities with regard to cleaning and social distancing and wearing, masks and engaging in safe practices that are consistent with the CDC and health department guidelines. If you are following the rules, if you are doing everything that you reasonably need to do to try to maintain a safe environment, you are not going to be, I just don't feel that you're going to be at risk of a lawsuit that a student was at school and got COVID. First of all, it's going to be very difficult to establish that student got infected at school, given all of the different ways that someone could potentially become infected. So my advice would be to follow the guidelines, do everything reasonably necessary to maintain a safe environment. And the good news is there's just a ton of good information out there right now as to what those steps should look like. So I think you do everything that you can that's reasonable and still manage to, get your job done, which is to educate kids. And I'm not horribly concerned about a risk of a student, or family suing the school because the student contracted COVID if you've basically done a reasonable job of putting in place good policies and procedures.
That's great. So Amy, I really congratulated us both on anticipating so many of the most difficult questions, but there is one in the Q&A that we did not prepare for that I think is really worth the last few minutes before we wrap up, which is, how do you recommend that schools respond if a majority of staff gathers to organize to say that they are not comfortable coming back based on fear alone and not documented ADA disabilities?
It's a really good question. It's a really good question.
Very difficult. Great question. Thank you for asking it.
And I think that frankly that there are probably schools that are facing this, not just locally, but all over the country right now. Because I know
And not just charters.
Yeah. I mean, district schools I know are very concerned about it. I don't know that there is a black and white answer to that question. And I think that if you are facing the reality that you don't have any teachers in your, to teach your classes, it's going to be kind of difficult to operate your school in a physical, in school environment. And so it's hard. It's kind of hard to answer that question a little bit in a vacuum, because it's so dependent upon, are there very specific concerns that the teachers have that they're able to articulate? Are there ways that you could address those concerns effectively? Would, part remote, part in the building satisfy those issues? I don't know. Are there steps that you can take to reassure teachers that you are doing absolutely everything humanly possible to create a safe environment for them to come back in? Are there specific things that they're concerned about that are not being done that you can address? So I think you could try to break it down from that perspective to see if you can meet their concerns and address their concerns. But at the end of the day, if you do have an entire, staff of teachers that are refusing to come, I'm not really sure how you operate a school effectively, with in-person operations when you don't have teachers to teach. So I don't know, Anna, if you have any thoughts about that yourself, but it's a really tough issue, and I'm afraid I don't have a brilliant and an easy answer to that question.
I totally agree, and I think you said it well when you said trying to explore what the concerns are and if there are ways to address the concern. But I do think that there is a risk in this moment of a little bit of mass panic, and people almost infecting each other with their concerns, and that there could be a moment where for some schools, the best option is to address those concerns by being remote potentially for longer than what the school leadership would prefer, in order to reestablish a sense of trust and community with the staff. I think it's incredibly difficult, and I think for so many school leaders, but also staff right now, balancing this sense of concern as well as the deep concern that folks have about students and their well-being and their academic success and status. But we all have to, the only way out is through, and it serves no one if in the process of going through there's some implosions of some of these incredibly important relationships that schools can't function without them, and that staff relationships as well as student and family relationships. So I think, I know schools have been working hard on their plans, which are due tomorrow. So thanks to everyone for taking the time the night before the deadline, if you will, to join us today. Amy, last question, hopefully an easy one, and I hope I'm not putting you on the spot. Can we drop your email address in the chat if people would like to follow up with you?
Absolutely.
Someone asked that in the Q&A. All right, so I will do that.
I'd be happy to do that. Yeah, I think one thing I would say, Anna, is I would say that communication, and this is what you were basically talking about, is communication around all of these issues could not be more important. And so getting input, listening to people's fears, sometimes they just need to be heard and they just need to articulate what's on their minds. And then you have the opportunity to reassure them of all the steps that you're taking to be, to demonstrate how important their safety and their health is to you, and what you've done to try to ensure that. So I think that going back to just clear, constant, repeated, frequent communication it's a really important part of this process.
Absolutely. And as difficult as it is to sometimes remember and to layer onto that, Amy and I were discussing in preparation for today that in addition to the communication piece, documentation. So if you are beginning to have these difficult conversations with a staff member, even if they have not yet treaded into the realm of legal liability, to follow up with an email and reiterate how much you appreciate the conversation and how much you care about their safety and concern and things like that. You know, it never hurts to have those things filed away for when something becomes more complicated, and your ability to say, like, it's not just I'm saying that I met with this person 5 times, right? I can show all of the email follow-up that I had, you know, that I had with them where I said, listen, if you're able to submit this documentation, we can have a different conversation, and they seem to be unable to. So communication, documentation. So Amy, thank you so much again. I so appreciate your time, your wisdom and your expertise. We will be posting this webinar, the documents Amy is willing to share on our website. And so folks are welcome to access those there. And please feel free to send along any additional questions that folks might have that we could cover in future webinars with the illustrious David and Susie, as well as the DOE. So we look forward to seeing you next Tuesday for our weekly webinar. And I should have said at the top of the hour that we're really excited and gratified that on Tuesday, Christina Coughlin, who heads the State Education Department's transportation team, will be joining us. We know you guys have lots of questions about transportation and how districts are managing transportation and what that means for charter schools. So we'll lead that off. We'll lead Tuesday off with that topic. And then please also join us next Thursday, a week from today at 4 o'clock for our Race, Justice, and Equity series, where Yomika will be facilitating a conversation with charter educators. So with that, we'll sign off. Thank you, everyone. Thank you, Amy, again. So appreciate it. Great to see you. Bye-bye.